Wednesday session 1, 751 waiver cases. This is when you get married to a US citizen and now from temporary green card to now the permanent green card. This is the key moment where you prove your marriage is real. So this is a session. We have top 10 things that we want to take away. Margaret and I, we do a lot of 751 cases, and so we learned a lot, and so we want to share all of them with you. Let's go.
So the first point is that if you're filing a joint I-751 petition, it has to be filed within 90 days. And if you don't meet that 90-day requirement, then you have to have a really good solid reason and provide an explanation to USCIS.
Now, though that may be true and though that may be what they say, we filed 751 joint after a year. And you think like, what, year after? Things happen, things change. So you can file a joint petition way after the deadline.
The second point is that if you're filing an I-751 waiver, that one does not have a deadline. You can file it at any time. But I did have a question for you, Joseph.
Mm-hmm.
Like, do people need, like, what if they need to work? Do they lose status if they file after the deadline?
The answer to that is actually kind of complicated. Practically speaking, there's no difference in the sense that your employer typically doesn't have an I-9 requirement to double check your green card validity. Now, if you file the 751 waiver, you get a receipt or you get an extension receipt saying that you can continue to work. That's kind of complicated because what if your original temporary green card ends and then you don't file the extension until a year later? Well, during that year, you're technically not eligible to work. Now, if you file it beforehand, no, you're not going to get an interview, immediately. Sometimes these go 4 years plus. And so even if your case is weak, our recommendation, still file it, deal with it at the request for evidence stage, deal with it at the interview stage. This is for a 751 waiver case.
So for point number 3, what happens if you got married, you got your green card, and you got separated, and then you move overseas?
You can still file the 751 waiver. It's obviously a hard case because you have to prove your marriage is real, right? You just got married, you just got the green card. Why aren't you living together? Why'd you get separated so quickly? And you're supposed to want to live in the US, you want the green card, and you've left, right? 751 waiver interviews, you get challenged. Do you even want to be here?
So for number 4, they talked about all of the different categories that you can file for I-751 waiver. One can be based on extreme hardship or cruelty that you suffered as the applicant. The second one is if your marriage was real, but then it ended in divorce. And another scenario is if basically your significant other passed away.
Pro tip, it's not mutually exclusive, right? Mm-hmm. We've done plenty of cases where we argued both. Typically, you pick one lane and you stick with it and you make all the arguments. But, what's there to say, I suffered extreme hardship and the marriage is real, right? If it can strengthen the case, why not?
The next thing we learned has to do with filing a new I-751. If you had previously abandoned your first I-751, then USCIS will just continue to adjudicate the next one. However, if you initially filed the first I-751 and there was a reason for denial, they will also deny the second submission unless you present really good and strong evidence.
This means don't give up hope if you have a weak case. Right? Because if they haven't adjudicated it and you have really good substantive information, you can file a brand new one.
And the next thing is in regards to changing categories, which we see happen a lot. So if you have a standard I-751, you were previously married, then you got divorced, and now you have to submit an I-751 waiver, then you are allowed to do that. And AILA basically talked about how you don't have to resubmit the new form. You could basically just send a letter to USCIS.
We've seen people go from being married, 751, to getting divorced during the 751 process and now have it changed to 751 waiver, and then get married again to each other and then change back to 751. So this could go on. I mean, we haven't seen somebody go from married to divorce to married to divorce, but hopefully, I mean, if they keep on dragging this out, 751 process for like 4 to 10 years, maybe that will happen, right?
The next point is in regards to the really long processing times and pretty much the next step, which is naturalization. So pretty much in the AILA conference, they talked about filing the N400 concurrently while your I-751 is pending.
So this is a shortcut to push them to adjudicate your 10-year green card faster. You can technically file for naturalization if you've been married to a U.S. citizen for 3 years, but the 751 adjudication time sometimes could be 4 years. So you don't want to wait another 4 years before you get your green card or your permanent green card. So after another year after you filed your 751, you can just file your N400 citizenship application, right? Because the requirement is you only have to be married for 3 years, assuming you meet all the other requirements. And then within 6 months to a year, you can get your naturalization interview, and you can also get your 751 interview done at the same time and get your 10-year green card.
And then I have a question. So what if they have an I-751 waiver? Can they still file for N400? And is it recommended? And what if the client maybe doesn't know if their I-751 waiver will be approved?
If you've already gotten divorced, then you're no longer married to a U.S. citizen, which means the 3-year rule doesn't apply to you, and you need to wait the 5-year rule to file the N400.
So how do you know if your marriage-based case is weak, or how do you know if you have a strong case?
USCIS, when they look at your case immediately, they kind of quickly adjudicate. Now, if your case is super standard, meaning you're married to somebody who demographically you're likely to marry, you guys are in similar socioeconomic classes, education is similar, like if it looks good and you have a lot of documents to prove it, that's a straightforward case. But if you're marrying somebody that statistically just does not match up, if you guys don't speak the same language, if the woman is significantly older than the man, those are strange. The other way around is almost common, right? But it's strange.
Okay, so what if you are in one of those predicaments? You're in an unconventional case that might just on the surface level maybe not look real. How do you strengthen your case?
First, don't hide it. They will know. Directly put it up front and then explain your circumstance. Explain your story. Every story is unique. Whether you got married very, very quickly after you met, or you've known each other and dated each other for years and years and years, and then you eventually got into a relationship, right? If you are in a unique relationship status that is unlike any other relationship status, prove that. Maybe you're both seniors. Maybe you are both disabled. You guys have unique stories that nobody else have. Do the things that help your case be successful.